So paragraph 18 is such a huge paragraph in the new contract between Amazon and its sellers regarding arbitrations that we're breaking it down into multiple videos and multiple articles for you. So I have Rob Siegel with me. He's the managing attorney here when it comes to arbitrations against Amazon. When Amazon refuses to release your money to you, they refuse to give you your inventory back, or you're seeking reinstatement. Oh, that's a really hard one to win. So I brought Robin here to talk about just specific provisions as a supplement to the video I shot a few moments ago regarding arbitrations. So Rob, what is most concerning to you as the managing attorney of our arbitration unit?
It's a good question, CJ. One of the most important features of the arbitration process is that it's supposed to be fast and efficient, both cost economic wise and timeline wise for sellers. Amazon's new contract is trying to take that away from the arbitration process. And what I mean by that is there's something called expedited arbitration.
Well, let me stop you for a second. Not only is arbitration generally supposed to be faster and cheaper, under the rules with the American Arbitration Association, which is the company that Amazon chose, they created this thing for an expedited process. We're going to be talking about how Amazon is trying to change the rules of the company that Amazon chose.
Exactly.
So what Amazon's giving is also now taking away, which we're seeing over and over and over again in this contract. So how is Amazon trying to alter the American Arbitration Association's own rules?
So it's actually in two different ways. The first is that all claims for less than $75,000 under the AAA's actual rules are supposed to be adjudicated under the expedited procedures, which normally mean that you're entitled to a hearing within 30 days of the arbitrator's appointment.
It also saves sellers a boatload of money because the arbitrators are stuck at a flat fee, which is $600 per side, rather than billing the sellers and Amazon by the hour. And as far as I'm aware, Amazon has more money than any seller out there. So that's a big difference, having to pay the arbitrators by the hour versus a $600 flat fee.
That's right. So Amazon's limiting those two features of the expedited rules in two ways. One is that instead of having claims up to $75,000 be per the expedited procedures, Amazon's limiting that claim amount to $50,000.
So Amazon is trying to change the AAA's rules, and it's not just the cost of the arbitrator, it's also the discovery process. For those of you who have never been involved in litigation, discovery is the process where both sides get to find out what's going on, what paperwork they have. You find out what's going to be argued later on at the hearing. And under expedited, discovery is very, very limited, which is often good for sellers because it lowers your costs. If Amazon is able to impose its will on the AAA, and we don't think the AAA is going to go along with it, but we don't know yet, it's going to drive up the cost tremendously, where it may or may not be worthwhile to seek between $50,000 and $75,000. You might as well go higher than that.
Yep.
What else are you concerned about, Rob?
Well, the other problem is, like I said earlier, the expedited rules normally, under the AAA's rules as they're actually written, say that a hearing is provided within 30 days of the arbitrator's appointment. But Amazon's new contract kind of takes away that feature of the rule and makes it so that hearings are within 90 days of the arbitrator's appointment, which literally makes the process 3 times as longer for a seller who's supposed to be out, less than $50,000.
Now, I know Rob like the back of my hand, and one of the reasons that he's smiling is because Amazon has consistently argued in multiple expedited arbitrations that its lawyers can't work as quickly as we do. They can't fit us into their schedule, even though they're represented by a huge law firm with offices all over the country, hundreds of lawyers. So we're pretty sure that our aggressive nature in these arbitrations has sparked this change among others in the contract. But it's ridiculous that Amazon is now going to extend out holding your money, delaying the case from 30 days to 90 days, after they probably already delayed holding your inventory and your money during the whole appeal and plan of action process.
Yeah.
Okay, what about the assignment provision in this paragraph?
The assignment provision is also kind of interesting. Our prior experience indicates that Amazon wasn't really, they didn't permit sellers to sell or change ownership of their account. But the new assignment provision has a very loose definition of the word affiliate and says that Amazon will allow, if you get their written consent, sellers to assign the agreement to any of their affiliates. And this is new language for the agreement. And for me, I'll read you the definition of affiliate. It says, with respect to any entity, any other entity that directly or indirectly controls or is controlled by or is under common control with that entity. And to me, that's kind of an ambiguous definition. So if a seller is looking to transfer ownership of their business, do something else, maybe even retire with all the money that they've made with Amazon, this is kind of interesting because for the first time it seems Amazon is actually lending a hand in that process.
Now, up until today, up until the new BSA, there were always two different ways that Amazon sellers transferred their businesses and cashed out. When I was in my 20s, the book The Golden Parachute was huge, which is a long time ago. And you did it two ways. Either you reached out to Amazon as a buyer and you asked Amazon for its blessing, and sometimes it was granted and sometimes it was not. But the vast majority of Amazon business sales were done without Amazon knowing, which made it risky, which lowered the value of the business. So the assignment provision we think is actually very good for sellers. However, Amazon still has very strong unilateral provisions in its contract where you can sell the business and that buyer can get shut down the next day. So it's good in a way, but the other provisions in the contract also make it very, very risky. What about the term of interest being removed from the paragraph?
So the new paragraph 18, which is the choice of law, dispute resolution, and the assignment provisions, it also has an interesting language that was in the prior BSA that's been omitted from this new drafted version. And the provision that's been left out says, Amazon's failure to enforce strict performance of any provision will not constitute a waiver of our right to enforce such provision or any other provision subsequently. And what that means is, if Amazon doesn't give you notice that you're doing something wrong, under the old BSA, that meant they could still suspend you, basically without notice. The newest BSA took this language out, which kind of goes with the new termination paragraph that says that Amazon's going to give sellers a right to appeal within 7 days of notice of a issue with their account. So
let me just interject here for a second. The contract is so vast that I'm breaking it up among our legal team here. And Amazon does say they're going to give you 30 days notice. That was the big splash in the news. There are three huge loopholes that Amazon has reserved for itself. In addition, Rob used some legal terminology. I want to make sure that you understand what it is. And again, if you're using someone to write a plan of action who doesn't know the legal terminology, who hasn't read the contract, and we know a lot of consultants out there, one guy in Boston, a woman in Texas, and a firm out in the UK, they don't even know this contract exists as far as I can tell. Okay, choice of law means what state's law is going to apply to the dispute. The arbitration can occur in New York or Florida or Arkansas, but the contract says Washington law applies. So it's Washington law and federal. That's choice of law. In terms of, we also talk about venue or locale, is where the actual hearing is going to occur if you have an arbitration. And a lot of times that really means where's the arbitrator going to be pulled from, because a lot of these arbitrations are done through telephone or video link. Okay, so they removed that language. The language about Amazon does not have to strictly comply. Amazon doesn't really have to comply at all, and they can still enforce all the provisions against you. That is yet another example of how one-sided Amazon's contract is, how it's Amazon has all the rights, sellers have practically nothing, and we use that one-sidedness to argue to arbitrators that portions of the contract should not be enforced against the seller because it's so terribly unfair. Okay, what is the new term of interest that Amazon has put in?
So it's funny that you just talked about how unfair and one-sided this contract is. And in one of the other videos that CJ is working on, we discussed the termination clause of the contract that new version will allow for notice. However, in this paragraph 18, Amazon once again slides in some shady language that could really mess sellers' business up, and I'll read it to you. It says, Amazon retains the right to immediately halt any of your transactions, prevent or restrict access to the services, or take any other action to restrict access to or availability of any inaccurate listing and inappropriately categorized items, any unlawful items, or any other items prohibited by applicable program policies. So to me, Amazon made a new termination paragraph, and then in the paragraph 18, all the way down at the bottom, they had this language saying, oh, but by the way, we can do whatever we want to you.
Yeah, also it's ridiculous how one-sided it is. Also, in one of the other paragraphs, and you got to watch all these videos. I know it's going to take sellers a lot of time, but you got to know what your agreement is. Amazon says they could terminate you for any reason at any time. The notice provision has a ton of loopholes in it, but yet it says you have to keep delivering products, which is absolutely crazy because Amazon will owe you X dollars. It could be tens of thousands, could be hundreds of thousands or more. And yet they're telling you to keep delivering products that they're not going to pay you for. Okay, so that is the supplement with Rob Siegel regarding paragraph 18. There is a ton here that sellers need to know about. So, two things. One, if you're learning from these videos, please like it and share it. Number two, find the time to watch these. We're also going to be putting everything that we're saying in writing so you can download it. We'll send you a copy of the book, whatever format it's in. Also, for plans of action, appeals, Bezos escalations, if you're not using someone who can read and interpret a contract and then use those terms to argue those terms right back to Amazon, you're paying for something that you're really not getting a fair shake. The only way to interpret a contract is to know it exists and to read it. And there's a lot of people out there who were former sellers, used to work at Amazon, they're in the UK, whoever. As far as they don't even know about the contract, and they're certainly not lawyers who can read and interpret it. Rob, thank you very much for helping me.
Thank you, CJ.
There is a ton in paragraph 18, and I appreciate you getting on film.
Definitely.